I don't think that we'd be able to accomplish that with any great. If I use courtroom B to broadcast to those that are suing from the courtroom, they would then go next door. As I indicated to counsel, if I were then also to go to the jury assembly room, that room is able to be divided. However, those that maybe should not hear the testimony, because I'm anticipating a
Yeah, I don't want to
semester,
feed in
I
because I'll have
can't
other
guarantee
victims in
that
there.
they can't hear
Right, if you close the wall.
if
I
I
got it.
did wall.
If there are family members that want to watch the feed for the partial closure for Noah and Maxwell, they could just go in courtroom B and sit on the other side of the courtroom.
They can do that.
Okay.
Or if, and you'd have to let the court know if there is some uneasiness, because the technology we'll be using to allow them to see it will not be our actual feed. It will be a Zoom feed.
Okay, but it'll be up on the TV.
It will be on the monitors in
Okay.
there.
That's fine.
If, okay, and we'll just make sure that we have personnel there to make sure.
Sure.
All right.
So I think with the court's ruling, no objection from defense, I would start, the first witness I would call would be the complete closure would be Isaiah. Then Noah and Maxwell.
Gotcha. Okay, and we're gonna have to, there'll be a bit of a break, so we just have to make sure that we can dial in from there and get this feed into courtroom B. I think we can do it, but we've had technology issues this morning and I go over there and next thing you know, the whole thing's blown up. Just I throw you under the bus there. All right.
And I did indicate to counsel in the court in our chambers conference that I do not intend on calling Priscilla Bird or Tia Shuet. And the other two victims I indicated to the court and counsel.
Correct. You did. All right.
And I guess I should place on the record, if I didn't already, my apologies. One of the other victims is not coming forward to testify because of safety concerns.
Okay. Okay. Very good. Is there anything else on the paper?
Just a point of clarification. Is that the same two alleged victims that you said you weren't calling?
Yes.
Okay. Just wanted to make sure that there wasn't a third person in that list. You have a motion.
Go ahead.
We just motion that the court sequester the witnesses from one another, given that these are allegations in this form, that we would ask that they be separated from one another throughout the preliminary exam.
All right. I am not separating the witnesses from one another. I will order, as I would customarily do in any other case, that the witnesses are hereby ordered sequestered from the proceeding. That means the viewing of the proceeding for those closed witnesses, the viewing on YouTube, all of that, witnesses are hereby ordered not to view those proceedings. I would also indicate that they are not to discuss their test. If they have testified, they're not to discuss their testimony with any witness who has not testified as of yet in this proceeding. All right.
Thank you, Your Honor.
And I would leave that to the people. I'm making that order. Leave that to the people to explain to the witnesses and the families. Because I also maybe going also to defense point, I don't want communication coming through family members to potential witnesses either. So
No, yes, Your Honor, thank you. We will have that conversation with the witnesses and their families. They will all be sequestered. Once their testimony is complete, they're free to watch the testimony if they want.
all right. Anything else?
Yeah, Judge, in this
And
point,
the only witness
Oh.
that's not sequestered, sorry, is my officer in charge, and he's seated to my left.
The officer in charge may remain in the courtroom. Go ahead, Mr. Towns.
thank you, Your Honor. It may be moot at this point, but the bill of particulars that I talked about with the court, well, it's not actually moot. It's actually something that we're asking, or we've asked for from the prosecutor, and it's important because it establishes dates, times, places, whatnot. And some of these cases, they're very different. They're very spread out. And my understanding from what the court says that we're not entitled to a bill of particulars prior to the preliminary examination, and it's not relevant after the preliminary examination. But we're making an objection on the record that we should have provided this particular item, especially with the amount of witnesses that are in this case and the timestamps and whatnot. It's very important for us to be able to establish alibi, establish where somebody was at, where and how it came together and all that kind of stuff. We don't have that information at this point.
Other than the issue, and let me just add to what I had indicated to counsel. As to the charges here, were place other than venue or the time an element of the offense, then certainly I might agree with counsel, but it's not an element of the offense. I mean, I certainly understand counsel's position, but they're not elements, so I don't think that people could supply those two in any event. I also believe that the people, I think we had gone through this at some point, at least part of it, have narrowed down dates as best that they can. And certainly you can inquire of any of the witnesses that testify as to those particular issues. Ms. Reiser.
And just briefly, Your Honor, for the record, I do believe that the statute is sufficient. A bill of particulars is not required. MCL 767.45 governs information and indicates that the indictment or information shall contain all of the following. A, the nature of the offense stated in language which will fairly apprise the accused and the court of the offense charged. B, the time of the offense as to the extent possible, and that the offense was committed in the county or within the jurisdiction of the court. And the felony information in this case does contain that information. It contains the charges of criminal sexual conduct and child sexually abusive activity and using a computer to commit a crime. To the extent possible, the date ranges June 27th, 2014 through September 30th, 2024, and those crimes occurred within Washtenaw County. So the felony information complies with the statute and with the court rule that governs that. That's MCR 6.112D. As well, the defendant has been provided with discovery as to what each victim will testify to and the dates that their assaults did occur. So I don't believe a bill of particulars is required at this stage, or quite frankly, at the next stage. I think that the court rule and the statute have been complied with discovery and with the felony information. Additionally, I emailed counsel back in November names of victims for each child sexually abusive activity count. And they're using a computer to commit a crime that corresponds to each of the child sexually abusive activity counts contains a victim's name. So obviously, I mean, that could change depending on their testimony, but everything has been really well laid out.
Go ahead.
Just to be clear, there are 2 counts on the complaint that are not associated with any alleged victim. They're count 2 and I believe count 11 on the complaint. Part of the reason why defense is asking for a bill of particulars is because we have a range of 2014 to 2024. We also are trying to protect our client from the state using anything that comes out in the preliminary exam as prior bad acts in the future. And that's why we needed to clarify what exactly what information or what actions are being associated with you and exactly when. So that is the reason why we asked for the bill of particulars. And there are 2 counts here that are not associated with any direct alleged victim in this case.
The, this is actually citing the case of People v. Harbor, 76 Mishap 552, 1977 case, but it is often cited that where the record does reveal that the defendant underwent a preliminary examination, and the defendant here is going to undergo a preliminary examination. When a preliminary examination adequately informs the defendant of the charges against him, the need for a bill of particulars is eliminated. Certainly, in the case law, I've not seen any case law where prior to preliminary examination, a bill of particulars has been required. But certainly prior to trial, defense counsel can raise the issue should that something not be clear or adequate, or they not have an adequate opportunity through this preliminary exam process to do that. I would cite that unpublished case that I'm citing from is just decided in February of 2025, just February 10th of 2025, where the Court of Appeals cited that, and that's People of the State of Michigan versus Marlowe. And I can provide copies to counsel should they so request. And also the Court of Appeals in April of 2024 also specifically held that we're generally where there is a preliminary examination, there is no requirement for a bill of particulars. So for the reasons as stated by the people, that the court does believe that the complaint and the information in this case is sufficient. They've been provided all of the discovery in this case and are about to undergo a preliminary examination. For those reasons, the court would deny the defendant's motion for a bill of particulars.
Thank you.
Last item, Judge, and this one I meant was probably moved, was the recording the CD that was just given to us on Thursday that we have been asking for. It's item number 22. I think it's in sub 1, part of sub 1, sub 2 possibly. I mean, obviously, we haven't had an opportunity to even listen to it at this point. I don't believe that they're actually calling the alleged person that would be able to testify to that. So I'm just making an objection on the record so it doesn't come down the pike. If something changes, that they would be able to bring that in.
Well, but
That one word no changes everything. Without Section 8 or rental assistance, Tasha has zero backup. See, government programs can sometimes buy tenants time, covering months of back rent and halting an eviction. But here, she's on her own. No safety net, no voucher, no lifeline. And in the courtroom, that means the judge has fewer reasons to delay the process. It's raw survival against the rules of the lease.
my understanding is, and I don't know what's contained on this CD, but the people don't intend on introducing the CD at this preliminary examination. And the witness that is attached to that CD is not going to testify at preliminary examination.
Correct, Your Honor. The CD that was provided to counsel on Thursday is the defendant making admissions to one of the minor victim's mother. It's a recording of those admissions. So
About that victim?
correct.
Okay.
So I don't intend to call her. I don't really think it's going to be necessary. So but I also certainly think Thursday to Monday was plenty of time to listen to the CD. And if they needed time to go listen to it right now, the audio is very difficult to hear on it. So I wouldn't play the CD in court. I would just have the mother testify to the things that the defendant told her.
All right. And my understanding, Mr. Thomas, is you've had it transcribed, cannot necessarily verify that transcription because you haven't had a chance to listen to it. But from the court's understanding, and again, I think that this is a moot issue if the witness isn't testifying, there's nothing on that CD that is going to affect or meld into these proceedings today. That's the court's understanding of that. And further, I guess I would agree with the people that from that time, they an adequate opportunity to listen to it if it became necessary. And certainly my understanding is it's not that long a one, so that if it did come up and council needed time to listen to it, the court would give adequate time to listen to it. So, all right. Anything else?
No, Your Honor, we're ready to proceed, and we would start with the witness Isaiah with the complete closure of the courtroom.
Okay, we're gonna have to take a break. I will order the courtroom closed. With respect to that witness, that will be a complete closure. With regard to the other two witnesses where I am closing, I will permit, to the extent defense would like it, for him to have two family members present in the courtroom while that testimony is happening. All right. Okay. Thank you. We're gonna go check, make sure we're working for B, so we don't have to move anything else.
And then when we begin, Your Honor, would the minor victim be brought back through the hallway so he doesn't have to walk through the defendant's family?
Yes, and that was one of the reasons also, so that council is aware, why it's an easier process for us if they are in B, but we can make it work from where they are now, and that way they don't have to move. But let us check, make sure our technology works, that we can do what I'm gonna request, all right? And it's recess. All right. Court does recall the case of the people of the state of Michigan versus Radcliff. Council, state your appearances for the record.
Good afternoon, Your Honor. Amy Rines on behalf of the people.
James Thomas for the defendant.
I don't know, Jody, on behalf of Mr. Radcliffe, Your Honor.
All right. And we will continue on with the prelim. Are you ready to call your next witness?
Your Honor, prior to calling the next witness, we just want to bring to the court's attention that it was brought to our attention that after the witnesses from this earlier today testified, they joined the room with the live stream. So we had asked for the witnesses to be sequestered. We didn't say we weren't going to potentially recall any of those witnesses, and if any new information came out and it was brought to our attention, they joined into courtroom B.
And that's correct. The witnesses were excused.
They were.
So I told them that they were finished testifying and they could watch the testimony.
And so what is defense's objection?
Our understanding was that the court had asked them to all the alleged victims, the witnesses, to be separated from each other, to be.
I did not order that. There were, in fact, I specifically did not. I told you in chambers that was an impossibility. And on the record said that. And specifically indicated that I would be issuing my standard sequestration order, indicating that they should not, those that have testified should not be talking to anybody that has not yet testified.
That is correct.
So if I had ordered that they all be separate, there would have been no reason for me to say that second part.
That is correct. But my understanding is that they were in the room with other family members of other alleged victims that were going to testify later today. And that's one of our concerns, is that they're sharing a space. These people already, as came out today, have a lot of connection with each other.
So are you saying that somehow or another their testimony is going to be tainted? Because if you're making that call, you better be ready to back it up, or you better back down from it. One of the two right now, because otherwise I will hold an evidentiary hearing regarding each witness coming up here, and you better be able to substantiate it. So before something else comes out of your mouth, let me know which way you want it.
Thank you, Your Honor. I was making the court aware of the fact that information was brought to our attention. We were under the impression that the court's order was that these witnesses would not communicate with each other in the sense of the testimony. All we're making clear on the record is that these witnesses joined a room full of other family, other members, families, and that's all we're making.
And they were excused. So had we not had that room, had they just been out in the hallway, they would have been out there amongst them anyway. After they're excused, I cannot and do not control them except for the confines of my order, the sequestration order, which tells them not to talk to anybody that has not yet testified.
And all we want to make the court is aware that they were in a room with other family members of those who have not yet testified.
And that means absolutely nothing to the court without more counsel. So I'm done with it.
Thank you.
Well, Your Honor, I would like to speak to the record because counsel is representing that something improper was going on. When from the beginning, I advised the court and counsel that there are approximately 30 people, 8 of them victims to testify. They're all being held in the jury room. I, as an officer of the court, told them not to discuss their testimony with one another. So after the
Okay,
beginning
let's,
of this hearing,
why don't, yeah, go ahead. And I don't-
they were all in the room together to be kept away from the defendant's family in the hallway. The intimidation